Thanks very much, Filippo. It's a great pleasure to be here in Chicago at the Stigler Center at this prestigious conference and to moderate this first panel at this pivotal moment for antitrust and competition policy. The title of this session is Antitrust, What Has Changed in the Past 5 Years? And like Filippo, I'm astounded by the pace of change. It seems more like 5 minutes ago that I was discussing with my colleagues at The Economist the novel proposition that maybe America had a competition policy and maybe antitrust policy needed to evolve. Now the intellectual landscape has changed, the people in charge have changed, but it's still quite uncertain where this is going to take us, and indeed the debate about the desirability of the changes that are going on is still running very hot. We have a stellar panel here today to get to the bottom of this issue, what has changed, and also where things might be going. And they're going to provide a really interesting range of perspectives on this question. So introducing them along from the far end there, Bill Kovarsik is Professor and Director of the Competition Law Center at the George Washington University. From 2006 to 2011, he was a member of the Federal Trade Commission, and indeed he chaired that commission between March 2008 and March 2009. In addition to his research, teaching, and advisory work, Bill recently had a stint as a non-executive director at Britain's Competition and Markets Authority. Sitting next to Bill, we have Dina Srinivasan, who's a researcher, lawyer, and entrepreneur, and a fellow with the Thurman Arnold Project at Yale University, and she is one of the principal intellectual architects of antitrust cases which have been brought against Facebook and Google, having written highly influential papers on each firm. Alex de Struel is Professor of European Law at the University of Namur and the Research Center for Information Law and Society. He's also chair of the EU Observatory on Online Platform Economy and an assessor at the Belgian Competition Authority. He's recently advised the European Commission and European Parliament on the regulation of online platforms. And lastly, we have Nancy Rose next to me, who's Charles Kindleberger Professor of Applied Economics at MIT. She's had a distinguished career researching and teaching industrial organization and competition policy and the economics of regulation. From 2014 until 2016, she was Deputy Assistant Attorney General for Economic Analysis. So a really stellar cast here to get into this question of what has changed. And we're going to start by giving each of the panelists an opportunity to answer that question from their unique perspective. And I'm going to start by asking Dina to talk about what's changed in ideas about regulating technology firms.
Thanks, Henry, and thank you for having me, everyone at the University of Chicago. This is one of my favorite yearly conferences, so it's always such a delight to be here. I was thinking last evening about the last 5 years, and one moment that sticks out for me is in 2018, Greg Ip at the Wall Street Journal wrote a piece about how there's really nothing to see here in terms of antitrust and big tech in the US, and I thought that his piece really captured the sentiment 5 years ago, and I'll point out 3 things that he had in his piece that I think we've done reversals on in the last 5 years. The first is the sentiment that the consumer welfare standard is very narrow and just about price. And so how can we do anything using the consumer welfare standard when going after big tech firms, because after all, their products are low priced or free. The second was this idea that was really popular back then that firms like Google and Facebook and Amazon are just naturally big and they naturally consolidate because of data and network effects. And it was something that people just said offhand. They kept, referring to data and network effects and saying, it's just natural that they would consolidate. And the third thing that he said is that, well, because of these 2 things, we'll never see regulation. There's no moment for regulation with respect to tech in the US. And we've done reversals on all of these 3 things, but I wanted to point out a few moments that I think allowed, that helped build momentum. I think for times like these, it's always about building momentum. And of course, one pivotal moment was Lena Kahn's 2017 paper about Amazon and the Amazon antitrust paradox. One of the things that paper did was to sort of question whether the consumer welfare standard, again, was too narrow in the US to go after big tech. At the same time, the University of Chicago, that's the sort of birthplace for this standard, was pushing back and starting these conferences and opening up the floor to critical thinking. And I think that was really important. And I'll just quote something that Professor Zingales wrote in the New York Times at the time, or gave the New York Times at the time. It was pushing back on this idea that Chicago's just about the consumer welfare standard. He said, Chicago faculty, however, abide by a method, not an ideology. It's a method of intellectual inquiry without the blinders imposed by conventional wisdom. And I think that these things together really opened up critical thinking and more rigorous thinking moving forward. And that's what we saw as a next stage in that 5-year process. Specifically, just rigorous thinking around these tech markets and these tech firms to dive deeper and really ask, well, what is Facebook doing? What market does it operate in? What's going on? And what we see are these stories that debunk sort of what we were thinking 5 years ago that were reflected in that Greg Ip piece. When it comes to Facebook, for example, Facebook rose to monopoly power by institutionally deceiving users about their privacy levels for over 10 years, right? And it was only after Facebook cornered the market and that Google exited the social market in the same month that Facebook significantly decreased privacy levels on consumers. This is a classic market power fact pattern. And the question then becomes, does this institutional level of deception in a market characterized by tipping and network effects constitute or pass muster as competition on the merits, even under the consumer welfare standard? And that's something that is in play, of course, both by private litigants and governments. But to break it down, this is a case that's being brought under the consumer welfare standard. So no, the consumer welfare standard is not narrow. It has nothing to do with price because consumers don't pay anything. So this is a consumer welfare case in a free market where the price is zero. Some of these cases are intellectually about defending people's privacy and curtailing surveillance. So in some way, they are defending people's rights in a democracy. And so the harms that we're going after are really interesting, even under this narrow framework. And when it comes to data and network effects, we do have, this is an example of a firm that was very open when it came to data and that was even more open when it came to allowing people to pivot from one social network to another or to take their contacts with them. And only after it gained market power did it sort of close down those API protocols that allowed those things to happen. So these are not like natural network effects or data barriers. There's really a pre-behavior conduct and then a moment in time where that changed to increase barriers to entry, and now the market is locked more due to these closed data and network effects issues. But again, even under current antitrust law, you can attack that kind of conduct when there's a pre and a post and a moment of change. I'll talk a little bit about Google. Now, again, I think 5 years ago, we were doing this thing where we were talking about companies in generalities. And we used to say things like, oh, well, Google is Google because of data and network effects, and it's free, and everybody loves their search product. And there wasn't a lot of critical thinking about, wait, where does Google make its money? Where does the money come from? Let's follow the dollars. Let's really understand this. And after we did that, we now have a proliferation of cases against Google. And this is one area that sort of I focus my research. There are lots of Google cases, so I'll talk just about this one. But Google is actually running the world's largest auction markets. These are auction markets that are bigger than the financial markets in terms of number of transactions traded daily. And the structure of these markets is also very similar to financial markets in that in these trades you have a buy side, a sell side, and you have exchanges in the middle. So you have markets where the structure of the market mimics the structure in financial markets. And as revealed in recent documents made public, even Google employees internally speak according to these analogies. And now we're in a situation where two things are happening. You have antitrust litigation against Google for its behavior in these auction markets, for conduct that we routinely make illegal in other markets because we understand their effects on competition. And so that behavior is in play from an antitrust perspective, antitrust litigation perspective. At the same time, we can draw parallels to legislation and say, well, we don't let the New York Stock Exchange own Citadel. We don't let those two companies be part of the same roof because those are unreasonable conflicts of interest. One of the things that happens with data in those situations is you have impermissible use of data. You have basically insider trading. And if we're going to apply the same rules and the same regulations to other exchange markets like crypto markets, well, what about ad markets that are also similar and even larger than any of those two? Do we just take the rules and the regs from financial markets and apply them to the advertising exchanges that fuel really all of the revenues for Google and Facebook? Because when somebody's making $200 billion a year, they're making $200 billion a year in these little micro auction markets that are trading buy-sell exchange. And so now we're in a situation where the Senate is rumored to be introducing a bill to do just that. And it has bipartisan support because, of course, we can, it's easy to agree that there should be structural separations or the management of conflicts of interest between a brokerage and an exchange. And it gets kind of fun because the regulation is riddled with things like non-discrimination rules that normally would be very politically divisive. But when framed as fair access, for example, to an exchange, it's a very non-controversial topic because this is a framework that the US has come up with that is a soft power issue, frankly, for America globally, our structure around financial regulation. And the last thing that I will say, and this is a little bit maybe just ending on a sobering note, this is all very exciting, but gosh darn it, we've been fighting antitrust issues in the real estate market for 20 years, and Americans everywhere are still paying 6% as a transaction fee on, $300,000-$400,000 purchases as the average American home price. That's insane. That's also a market that has gone electronic, largely so. And how we've had a lot of antitrust regulation, lots of DOJ scrutiny, lots of investigations, and Americans in 2022 are still paying 6%, that's a very sobering fact. So I'm not sure how we pull out of this and actually make change happen and make it work, but we've got to figure that piece out. Thank you, Henry.
Thanks, Dina. As a Brit, I'm endlessly fascinated by that 6%. It doesn't exist in Britain. You come over here, and it's immediately extremely striking. So that is a pessimistic note. I'm going to let Bill talk now, probably a bit more broadly than just tech. But after that pessimistic ending, maybe it's incumbent on you to bring some sunshine, Bill. I don't know.
No, absolutely. I have the power to do that. Thank you, Henry. And thanks to Filippo, Luigi, and Guy for the opportunity to participate. Thanks. To note a couple of things that have changed in 5 years. You're aware of the extraordinary transformation in the United States, and I think transformation is the right way to describe the policy advocacy because it captures best what the advocates of a realignment have sought to do, not modifications at the edges, but knock it down and build it back up. New people, new institutions, new framework. I think that when public policy schools in the future study effective policy advocacy and efforts to challenge a well-established conventional view of the world, what seems to be an immutable area of policy, they'll study what the transformation advocates have done, because that will stand out as the best example about how to build a new literature, how to build new conduits for information sharing and gathering, how to circumvent the status quo. Just bypass it. Don't attack it head on, but circumvent it by creating your own community, new scholars, new means of communication, shrewd forms of advocacy, a good eye for the moment that allows policy change, and to inspire debate about who serves. And notice that who would have predicted, how many of you went to your bookmakers 5 years ago and said that the famous firm of Kahn, Cantor, and Wu would have the positions they did now? How much did you bet on that 5 years ago? And I bet you can't show me your winning ticket because I doubt that it exists. Just to take stock of how breathtaking that change by itself is, that's remarkable. And certainly the antitrust establishment never saw it coming. And I think today is still bewildered. Both the center left and the right can't quite figure out how that happened and how that took place. An astonishing policy change. Second thing that's changed is that the appetite of public authorities for intervention has grown stronger. The risk appetite has changed in notable ways. There are big cases, Dina referred to the litigation program, but there are big cases running now that weren't running 5 years ago. All the litigation involving Facebook and Google, to take two, cases against Amazon. In the US environment, each federal agency and many state governments have bet your agency cases now running against the leading figures in the field. What's a little bit sobering about that is how long they are likely to take. Impossibly long. Can you believe that the trial date in the Facebook case has been set provisionally for February 2024? That case, if it goes through appeals, will not be resolved until 2026, maybe 2027. Not exactly the speed of light. And the Google example is not a whole lot more encouraging. To think back to the Microsoft case, one that's forgotten, so yesterday, the complaint that DOJ filed in the Microsoft case was filed in May 1998. It went to trial in October 1998. The appeal through the DC Circuit was completed by July 2001. That was barely more than 3 years from the filing of the complaint to a decision in the Court of Appeals. And that's not going to happen here. So you can wonder, despite the new activity in the US, is the antitrust technology fit for purpose anymore, the conventional mechanism? I think there's a reason to be concerned that it is not. But the cases are running. That's important. I think we have reflected in the work of a number of agencies the new risk appetite. And one thing that's new that wasn't so vivid in 2017 is the emergence of authorities outside the United States as notable players. I'm going to highlight one that, as Henry mentioned, I have an affiliation with, and that's the Competition and Markets Authority. What it's done is build the best research program in the field. It has built a litigation program that has major ambitious cases involving merger enforcement, abusive dominance. It is positioning itself to implement the DMU, whatever form that ultimately takes, and crucially, it's building a staff to do this work. What they decided 5 years ago was that having an agency that consists chiefly of economists and lawyers is not going to do the job in the tech space. They said, we're going to build a team of technologists, computer scientists, engineers, and quants, because they have to be able to understand what's going on inside these institutions and organizations in order to do good work. They have a team of 50 people now, 50, that provides support for work throughout the institution. There's not another agency on the planet that's doing that now. And I'd assert that without building that capability, you can't do effective work in this area. You will not succeed. They built 50. That's an extraordinary investment over a 5-year period of time. When it was happening, a number of observers said, why are you doing that? That is, why are you making the capital investment? And the answer was to be able to do good programs that will run over that infrastructure over time. I'll assert to you that it's the best competition authority on the planet today because of how they built the means to do the job right. Now, of course, there's a lot of work to be done. How will it turn out? I don't know. But if I were going to place a bet on any single agency that's positioned itself to do effective, successful work here, it's the CMA by far. I didn't do it, but I certainly got to see it happen alongside other agencies that were not doing it. The US agencies are desperately far behind in building that infrastructure. Another thing that's happened is that with the emergence of the diversity of effort, the multiplicity of effort that Dina referred to, is there's a growing recognition by agencies that the effective strategy is going to be working collectively to hunt in packs, not to work individually. That building a large coalition that has some coordination on the prosecution of cases, some coordination on the formulation of theories, some coordination about the strategy of phasing, puts you in a position to do several things. One is to go down the learning curve collectively in these cases, which is vital. Second, to blunt political opposition, enabling you to say, I'm not a rogue crazy agency, I'm one of 20 rogue crazy agencies, or 5. It's harder to make the argument that you're out of your mind if you've got a lot of company. And third, to build a research program that puts you in a position to amass the work and understanding that enables you, instead of chasing from far behind to understand what's going on, to be at the state of the art. That in many ways is a result of COVID and a recognition that desperate necessity pushes you in the direction of a deeper form of collaboration and policy integration that didn't exist before. And a related form of cooperation, I see this most strikingly in the UK, is a decided effort among the related disciplines of competition, consumer, data protection, to work together, to see the formation of dedicated teams across agencies that are working together on matters. The collaboration that happened on the Google Privacy Sandbox matter is a 3-agency cooperation that went beyond writing an MOU, who cares, but actually putting staffing behind it to make the development of the program effective. That wasn't happening 5 years ago. It's happening now. That's a major policy change. I'm going to finish by mentioning some things that have not changed. The US courts have not changed. The Biden administration has shown no evident effort in picking appellate judges who have deep background in competition and consumer protection and want to push the regulatory agenda towards more intervention. It's been a year. You don't have much time. Where are your Borks, Scalias, Doug Ginsburg, Steve Williams, Richard Posner's, Frank Easterbrook's? Where are these people? You haven't picked one. And if you don't start putting your friends in there to do this kind of work, as these cases come along, good luck. Because that's a major change that's going to take place. So the courts haven't changed a whole lot. That's daunting. Not impossible, but daunting. US legislation, well, Mr. Godot has been said to be coming for a long time with new laws. More money? He's coming. Hasn't shown up yet, has he? And exactly what is he going to do? I don't think he's going to do the fundamental rework of the US competition doctrine system. You take the recommendations from the Cicilline majority staff report, you have a shopping list of cases they wanted to change. They're not going to do that. It's going to be something on tech, but will they do that symbolically and say, hey, we did the job, time to go home? Or are they going to not only provide a broader platform, better tools, fix the FTC's many institutional disabilities when it comes to power and authority, clarify points that would be easy to do? Are they going to do any of it? And yes, where's the money? Where's the resource to support this? Where is the backing to put at least the agencies on the footing of the CFPB? Or are we just going to talk about what to do? And adding new bodies by itself is not going to be enough. You need the capabilities and the depth in order to do this kind of work. Those things haven't happened yet. Maybe some of them will be coming. My gloomy thought is that if you don't build that infrastructure effectively, you will replicate the experience of the 1970s when we had a major attempted transformation and major new legislation, major new cases, but the infrastructure lagged so far behind the initiatives that the initiatives, in many instances, fell to pieces. And we don't seem to be recognizing that if you want broadband quality policy results, you can't do it on dial-up institutions, but that's what we're willing to pay for at the moment. Last, a little bit more, a bit of optimism, but also pessimism. I see real estate a bit differently. I don't think it's 6% everywhere. There are places where it is not 6%. It is fee for service in a number of instances. Why did that happen? A case called Real Comp that the Federal Trade Commission brought, a report that the FTC did, some efforts by the DOJ. The issue is, why wasn't there a persistent effort to carry that forward? And I'd say a grave problem that you face right now is that if you accept the Joe Biden 40 years of failure precept, if it was 40 years of failure, why would I ever look back to the wasteland to learn anything and carry it forward? Because it was all depraved. If you don't look at the past 40 years, there are a few nuggets there that are really good for your program to carry ahead. But if you can't have a somewhat discriminating eye about that, you're going to build it all from scratch. So, good sign, there are things there that worked and are useful. Sobering side, do you want to learn from it?
Thanks, Bill. Just picking up on something you said at the start there about how new forms of media and tech in some part enabled the changes that have taken place, enabled the subversion of existing ways of thinking within antitrust. I find that quite interesting that even antitrust itself is not immune to the sort of societal changes that technology is forcing on society and in which antitrust scholars are themselves so interested. Nancy, your perspective is from academia, often said to be a lot more slow-moving, fairly or unfairly. Can you give your sense of the extent to which academic economics has contributed to the changes that have recently taken place?
Sure, and I'd like to also weave in a bit of my perspective as a former enforcer. Admittedly, part of that failed 40 years. Maybe give you a little bit of a different perspective on that. Is this on? Can you guys hear me? Okay. So in terms of academics, it's interesting. In some ways, we're slower moving. In other ways, much faster. And in many ways, I think part of the challenge that I've seen over my career is that there have been many academics, and I'll speak primarily to economists, but they're also in the legal community, who have been writing for decades on the failures of competition policy, on the need for more assertive enforcement. So, you've got, again, decades of merger retrospectives suggesting that we're allowing through mergers that have adverse competitive effects. There's a very rich literature, both theoretical and empirical, on the ability of firms to use vertical relationships to foreclose competition or disadvantage rivals. That started, even before the Chicago school said, anything vertical is just pro-competitive. Work that's engaged in exclusion and predatory behavior. I think, what I see that's changed over time is that those early voices maybe spoke to one another but didn't really have a lot of traction often in terms of moving quickly into policy. And the most exciting thing for me in the academic sphere has been to see the cadre that's growing, particularly among younger cohorts of economists and scholars. And I'd add in the lawyers into that space as well. They bring the kind of passion and enthusiasm that Bill mentioned, typifies this kind of movement. And they're helping to advance new theories of competitive harm that I think if we look carefully at how competition policy gets transmitted into action in the US system, you need to have those advances. Now, I don't think that's new. I think that's been something that has been taking place over time. I mean, even during the 2.5 years that I was at DOJ, I could see the evolution of thinking about cases, investigations, and bringing challenges that reflected the body of work that had been done in academics, along with the insights that career staff have from, often years of experience looking at particular industries, bringing those into challenges. So things like introducing bargaining leverage theories of harm, which don't rely on output effects necessarily to demonstrate harm. Those are really important in the healthcare setting, but they're also important in telecom. Thinking about vertical harm and exclusionary behavior. Upstream harm, which, there's a big focus right now on labor markets, but it's not just labor markets. It's any seller of a product who's facing reduced competition from buyers of their product. Stealth acquisitions, killer acquisitions, all of these have been the subject of some previous economics work, but increasing work. You know, the one thing I will say that I think sort of started with a bang 5 years ago, and I think, at least in the academic sphere, has reached a much more ambivalent point, is the literature on rising concentration. So if we think about rising concentration as reflecting the concentration of business activity in kind of fewer firms, I think that that fact seems to stand out, seems to stand up to further analysis. But if we're thinking about whether the kinds of concentration measures that came out of macro economic analyses or often in the media or think tanks, whether that reflects reduced competition that consumers or purchasers or even suppliers face, I think the work that's been done over the last few years is much more ambivalent on what that suggests. I want to just take 2 minutes, however, to talk about my perspective as an enforcer, to say a little bit about what I see as changes. I'd echo most of what Bill has said, and then what hasn't changed much or hasn't even changed for the better. So first, as Bill mentioned, as you all know, there seems to be much greater appetite for riskier challenges. I think it's premature to assign that to the triad of Kahn, Cantor, and Wu, because the cases that have been filed to date were cases that all started prior to those individuals coming into their leadership positions, indeed prior to the Biden administration taking over. While we might celebrate the appointment of leadership that is really motivated and dedicated to pushing forward competition policy enforcement, let's acknowledge that that has started well before they took over. There's an enormous policy focus, and as you all know, there have been a lot of hearings and bills introduced in Congress. Most of that has been focused on tech. And that worries me, frankly, because while everybody in this room is concerned about tech and lots of the world outside is concerned about tech, and there are very good reasons to be concerned about that, I don't think that that's our only competition policy problem. I'm not even sure it's our most significant competition policy problem when we think about the whole rest of the economy and the difficulties that we have enforcing, say, just merger policy. So let me just mention what hasn't changed or much or for the better. There is an ongoing merger wave. The HSR filings, I think, this past year were their highest ever, right? Those are the notifications to the agencies of mergers at which they get one bite. They can choose to investigate, and if there's a problem, challenge, or they can choose not to, and if that merger, and they're on a very strict time limit, and if that merger goes through, it's extremely difficult to challenge later and undo it, even though the leadership in the FTC has said, we're holding that option in reserve. So that puts an enormous strain on the agencies. Bill mentioned that there's really been very little response to an ongoing, persistent discussion by everyone who knows anything about enforcement agencies, about the agencies being under-resourced. So they're understaffed, they're under-resourced, and I think as significantly, they are undercompensating their career staff, and that makes it difficult to attract and even more difficult to retain experienced staff that you need to run these big cases, and as well as enforcing against the merger policies. Third, the courts and the legal environment are not just a speed bump. They're an enormous block, and as Bill mentioned, we've done nothing to substantially change that, and indeed, given the previous administration, the courts have continued their shift toward an anti-enforcement, kind of pro-business position. And that, with the most well-intentioned, enthusiastic, passionate agencies in existence, I think is going to make it very difficult to achieve what people want to achieve. I think you can just look at the 2 recent DOJ losses in wage collusion, no-poach cases in the labor market setting. Stunning, to me, stunning losses, right? Collusion per se illegal, and the DOJ could not win convictions in those. While I know that it's fashionable in some circles to say, well, we're going to bring aggressive cases, and if we lose them, that'll just tell Congress that they need to do something. I do want to end on a sobering note, which is to remind us that there are worse things than losing a case. First, I'm not at all optimistic that Congress is going to do anything substantive, particularly on the broad antitrust front, as opposed to maybe a few interventions in tech. But if you're not convinced of this, go read the Supreme Court decision in Ohio v. Amex, which the court weighs in on, what it tries, I think, to establish as a narrow, two-sided simultaneous transaction market, but which defendants have now, across the board, tried to, in every case possible, say, we've got a two-sided market, and the Amex decision makes it almost impossible for you to enforce any challenge against our conduct in those markets. And so to have that kind of precedent out there, increasing the difficulty for what was already extraordinarily difficult in the US to enforce against anti-competitive conduct, to have that precedent out there, I think should make us all a little sober about, trying to hit home runs when in fact there's been a whole wall that's been erected just beyond the batter's position to block any balls from moving forward. So I see that as a challenge, and it would be awesome if we could figure out a way, either legislatively or through court appointments or through some combination of the two, to help us with this agenda of making more effective enforcement.
Thanks very much, Nancy. I'm sure we'll come back to that subject of the courts, which is coming up a lot here. Alex, could you give us the European perspective on what's changing in antitrust? I was recently writing about these issues from a global perspective, and I was struck both by the contrast across the Atlantic and how it seemed like things such as the consumer welfare standard actually meant different things on both sides of the Atlantic. So tell us where Europe is and the extent to which you can draw parallels between what's going on there and what's going on here.
Yes, thank you very much for the invitation. So I would like to make maybe 4 points, two which are more substantive, two which are more institutional on what is happening in Europe. So my impression that is in Europe, the debate is much less polarized than here, and also maybe on less fundamental issue and to some extent different issue than here. So as you just said, the normative standard is not really at the center of the discussion in Europe, I think. There is, of course, some discussion whether we need more or less economic approach, and the Intel case that has been recently decided by the General Court in Europe, which is tending toward a bit more economic and effect-based approach, is interesting. But I think the normative standard remain really rooted in the ordoliberal tradition that we have in Europe since the beginning, in fact, and which is consumer welfare and competitive process. So the two aspects, and I think the court always repeat those two aspects. So I think I would say that the debate is a little bit not on that fundamental issue, and also less polarized. I mean, if you read, for instance, the strategy communication that DG Com has adopted in November 2021, they adopt this strategy for what should be the European antitrust. It's really a boring read, if you want, because there is really nothing new there. I mean, they speak about digital, they speak about sustainability, but I would not say, but maybe some would disagree, that there is really a lot of innovation there, except maybe the end, where there is the issue of the European Chip Act, which is discussed, and where clearly there, and that's the second point I want to make, I think the issue in Europe is the relationship between antitrust and other instruments. It's not so much to try to include everything in antitrust, but how you organize the interaction between antitrust and, for instance, industrial policy, or this willingness that you find more and more within the Commission and within the member states of having a European autonomy. And I think what happened with the European Chip Act is interesting, because clearly there you see that the state aid rule have clearly been relaxed by the European Commission to allow those subsidies to attract more chip factories in Europe. So I think that's where you could see a tension, and this tension is probably one of the most important that is discussed now in Europe. Another thing, of course, and it has been mentioned, the tension or the interaction between antitrust and privacy protection. Okay? So clearly, I think on that, the European Commission has kept a relatively traditional approach when they have, for instance, authorized the Google-Fitbit merger with remedies, but they didn't prohibit it. And so they clearly said again that antitrust is not a tool for privacy control. And then we may have a third interaction, which we see more and more between antitrust and sustainability goal. But, you know, I personally don't think that antitrust should do everything, as Filippo was mentioning before, but what we need, and Bill was referring to that, is those kind of forum where the different regulatory authorities which are in charge of different instruments cooperate with each other. I think to me, and you refer to the UK experience with the Digital Regulatory Cooperation Forum, is a very interesting one, but I think it's a better one than to say, okay, the antitrust authority should do everything. I think it's better that everyone keep its own role, but they discuss and cooperate with each other. Now, the two other points that I see at the institutional level is first regarding DG Comp. Because with DG competition, so the federal level, if you want. Because what is interesting is that there is more and more, and DG Comp may evolve towards a quasi-regulator, not only a kind of pure antitrust authority, but a quasi-regulatory authority. And there is two initiatives which are going in that direction, one which was aborted and the other one which was adopted. The one which was aborted was the new competition tool, you know. So the idea was that the European Commission, and DG Comp in particular, will have a new tool which is the same as the market investigation that you find in the UK, in some other jurisdiction, like in Mexico or in South Africa. Now, if that proposal would have passed, that would have meant that DG Comp would have really a powerful tool to investigate every what they call case of structural risk or risk of lack of competition. And we mean, for instance, oligopolistic market or tipping market, and the DG Comp would have been able to impose behavioral and structural remedy. Now, this thing, as you can imagine, led to a strong opposition from the business in Europe, and so was abandoned for now. But I would not exclude that it will come back at some point. I think the debate was a bit too much rushed, and that is why it failed. But I would not exclude that it will come back, and personally, I think it should come back. But then there is this other more narrow initiative, which is the Digital Market Act, which is an important one, but it's just on digital. But there again, I mean, DG Comp will probably be the main enforcer of this new piece of law. And what will be interesting to see is how the enforcement of this new piece of law will evolve. Because I see two possibilities. Either the DG Comp, so the European Commission, will only do some sporadic intervention, as they are used to do in antitrust, so a kind of hit-and-run strategy. You intervene when there is a problem, and then you leave the market and the firm, or whether we will evolve towards a fully-fledged regulatory system where DG Comp will have a constant and deep oversight of the big tech, like we have in banking regulation. Now, my prediction is it will be more the second, so a kind of deep and constant oversight of the big tech, but that will completely change the role of DG Comp, which is much more used to a kind of hit-and-run strategy or sporadic intervention. So, I mean, that is really changing the nature of what our federal antitrust agency is doing. And then, and that's the last point, institutionally, is the role of national competition authorities. So the authorities of the member states, not the European one. And there what I see and what we see in particular in digital, but also in other sectors, is that they seem to be much more innovative and daring than what the European Commission is doing. You know, if you see the German Facebook case, which considered a combination of personal data as an antitrust offense, if you see the French Google case with the relationship with the press publisher, which thinks that it's an unfair practice that Google do not pay the press publisher. I mean, this is something which is really pushing antitrust to the extent that the DG competition is not doing. And that is that will continue, in particular with the DMA. I mean, the German competition authority has already clearly said, I mean, the DMA is a kind of minimum harmonization for Europe, but we can and we will go further than that in Germany with our new law. So, you know, I think that that's interesting because that is showing that the national authorities tend to be more agile and more ready to experiment than the European Commission. And maybe we see the same thing in the US, in fact, where some attorney general go further and are more agile than the federal agencies. So there is pros and cons in that, of course. The pros is that it push the innovation further, I mean the antitrust innovation further. The drawback, of course, is that it risks of leading to a kind of fragmented and differentiated antitrust enforcement across Europe, undermining potentially the internal market. And so I think it's very important that we rethink maybe the coordination between those national competition authorities and the Commission. And it's exactly what Commissioner Vestager has announced last month, that they will rethink, I mean, they will rethink the decentralization process, not necessarily to say that it will be abandoned, but I think there is a lot of rethinking the learning that can be done at the national level, how that can be imported at the federal level.
Okay, Alex, could I put one thing to you, which is that Nancy said that she wasn't convinced that big tech was the most important antitrust policy in the US. Where do you think it ranks in Europe? Is it definitely the most important ones? How much are you worried about other things going on in the European economy?
Well, I agree that it's not the most important problem, but it's still the one which attracts the most attention of the regulatory, of the antitrust authority, and for different reasons. Because first, I mean, it sells well, that's clear. Second, because that's where you can really, we are at the frontier of antitrust, you know, and that with those cases, you can also help the antitrust theory of harm to go a little bit further. So it's a good tool, you know, to push the frontier of antitrust if you want to do that. So I think it's in a way logical, and yet there are several problems with the big tech. But I'm not sure that antitrust is the solution for the problem we have in big tech. And I think antitrust has other problems to deal with.
Could I just? So when I say it's not the biggest, it's a big problem. What I particularly want to say is, like, worrying about 4 or 5 firms and thinking that's going to solve our problems. I think we've got a much larger set of issues if we want to prevent the next 4 or 5 firm problem from developing.
Who needs to do what seems to be a big theme here on the European side, you know, with the delegation or otherwise from the European Commission to the national authorities. In the US, with this balance between legislation and the courts and so on. I mean, is it even right to think about some of the rethinking that's going on with respect to big tech as antitrust policy? You know, people are talking about antitrust being asked to do too much, but if the Klobuchar bill passes, for instance, if Congress just decides it wants to implement regulation on the tech industry in a new way, is that really antitrust policy being asked to do more, or is that a separate set of issues? Bill, what do you think of that?
To some extent, it is stretching the antitrust system, but it does also implicate a variety of other policy domains that are adjacent or overlapping. And I think Alexandra just mentioned a key need, which is how do you achieve policy integration? How do you do 2 things? One is how do you develop a strategy that brings to bear these different capabilities in a way that enables you to work? And by the way, that strategy is going to be long-term. That is, if you want to put this in place, this is building an infrastructure that's going to take time, but will serve you for a long time. The last previous major policy transformation attempted in the US was 1980-81. Having lived through that wrenching transition, what strikes me in comparing that experience is that Reagan had 2 terms with Bush following. That's 13 years to imbue the agencies with your philosophy, your appointees, your judges on the courts. I think if I were thinking now about these integration tasks, I'd say, where do we want to be in the next 5 and 10 years? It's partly a question of how many elections you're going to win, and you have a consistency of appointment, which is unknowable, difficult, but to see this as a long distance event, where you want to start thinking now about building the relationships strategy inside agencies and across agencies. And there are some models now you can draw on. It's a place where academic hubs, I think, can play an enormously useful role in helping map out what this policy space looks like, what the intersections are, and to draw from what we know about management and planning. And here I pitch the CMA again. I've never seen a better methodology for setting priorities, program development, and project selection, where this is the focus of what they've done in so many ways, to carry that across to a multi-agency cooperative framework, but to realize it takes time. That is, the relationships do not emerge spontaneously. You can draft cooperative instruments, but unless you have sustained commitment from the agency top, middle managers and case handlers, it won't work. But to model this as a long-term program to build a policy infrastructure that is fit to purpose.
So I'm really interested in that contrast between the speed of the change that's taken place in terms of the leadership and the length of time you're saying it's going to take to actually achieve meaningful change. Is it possible that what we've seen recently is more cosmetic and fizzles out with a change of election or another Twitter revolution or whatever?
The big bang that I go back to that's so remarkable and powerful is the change in the intellectual environment. That's Nancy said you start with an inventory of ideas, and you certainly do. They're a catalyst. But then you need an implementing mechanism to put them in place. And I think the ideas are there now. There's a will to use the ideas in a much bolder way. But what about the infrastructure to make it work, delivering? And the concern in the background is that if you promise the universe and you can't even deliver Kansas City, that's a source of cynicism and doubt about what you do in the future. So I'd say the idea is so important and so remarkable. And a lot of it happened here. People in the room here were responsible for that. But to build the mechanism to carry it out and realize over a period of time, that's, I guess, to create the awareness that we expect that to happen, that we don't just want more cases, we want more mechanisms to make sure that they'll work and to make that part of the report card. What's the basis for the grade in this course? Yes, it's the deliverable outputs that we see in the form of these initiatives, but it's also building a system that ensures that once the takeoffs happen, the landings will be good too.
One thing we haven't discussed an awful lot, Nancy mentioned it briefly, was antitrust and labor markets, which seems to me to be an increasingly sort of fashionable area, and it seems that policymakers are interested in that too, the extent to which antitrust policy should be thinking more about monopoly power in labor markets and so on. Dina, do you have a perspective on how that applies to big tech? I mean, I know they've taken some heat over stitching up labor markets. Is that an important part of the debate?
Which part of the debate?
About.
I haven't followed the labor market issues closely.
Oh, okay. Nancy, I know you've written on these issues, and I think you were especially concerned that the pandemic might sort of interact with what's going on with competition in the labor markets. Do you have any comments to make on that?
So I think it's a great area for antitrust to be pushing further on. I think in the merger context, which is where some of this has been playing out in the debates over increasing concentration of labor markets and the role of merger policy and disadvantaging workers. We've got the first challenge brought by DOJ that is founded, I would say, solely on labor market harm, which is the publisher's case, the Penguin Random House Simon Schuster merger case, where the challenge was founded on harm to authors. They've defined a pretty narrow labor market there. Some people have complained, well, they're worried about best-selling authors. They're not the workers we should be protecting. But again, we go back to, in the US, antitrust is a case-based precedential system. So if we can get case law that says we're protecting this class of workers, and that's the case DOJ thinks it can win, that opens the wedge to, I think, protecting many more. The intersection with tech that you mentioned, I think, the most obvious intersection was the Silicon Valley no-poach case that DOJ brought as a civil case. One of the concerns in the Obama administration was that they were seeing no-poach cases That is, employers agreeing not to hire from each other, which reduces competition for workers. Those were being brought as civil actions, and I think DOJ and the FTC were concerned that civil isn't as much a deterrent to collusion as criminal, the threat of criminal action is. So the DOJ and FTC released guidance in 2016 saying future no-poach, naked wage-fixing cases would be brought criminally. I think we expected with the previous administration, there was word that criminal cases were coming, they were coming. They didn't come till very late. We've just had the two that I mentioned that were brought and went down in flames with juries. So I think we've got a lot of challenge. Even the will to protect workers, which exists, I think in both of the agencies, they've got to figure out how to win in court if the deterrence is going to matter. But I think it's something that increasingly is getting attention, and the principal deputy at DOJ, Doha Meki, has been working on these issues at least since 2015 when I was there. And I think she's very concerned with how to implement more effective protection and enforcement in that space.
Do you think the academic evidence is there that monopsony problems in labour markets have gotten worse? Are people waking up to that, or was it always a problem which only now people are coming to recognise?
Yeah, when we say monopsony, it's a little bit like market power in I/O, and that encompasses a very broad range of problems. So you can get monopsony power from information problems or search costs, and that's not really a competition problem. I think the best evidence on competition problems, worsening outcomes for workers. The best paper that I've seen is Ellie Prager and Matt Schmidt's paper on hospital mergers, which shows that if you've got mergers that substantially increase concentration in the hospital market, not all workers are harmed, but the workers who specialize in healthcare, not surprisingly, who might be most affected by this increase in concentration in employment, do experience lower wage growth. And so I think what that suggests to us is not that we want a really blunt instrument, or not even that we want agencies probably spending their scarce resource dollars investigating labor market harms all over, but we want them to target where labor market harms might differ from product market harms and go after those. Iana's here, and she's done a lot of work on kind of broader relationships between concentration and wages and wage growth. And I think figuring out how to implement some of the insights of that for, how do you decide where these potential labor market harms are is going to be an interesting and potentially very fruitful avenue for the agencies.
Alex, to what extent are labour markets on policymakers' minds in Europe?
Again, I didn't follow it that very well, but my impression is that less than here in the antitrust field. But again, I mean, in other field, in regulatory field, a lot. And so there is this, if we go back to the big tech, there is a new proposal by the European Commission on the platform worker to try to, let's say, improve their conditions. So it's not the same problem, but just to say that very often, I think in Europe, we try to use also regulation to solve the problem. And there are two reasons to that. I mean, there are several reasons, but one is because we believe more in regulation than in the US, that is clear, but also because it's possible to pass regulation in Europe, contrary to here, So, because in a way, and that's what is interesting, the European Parliament is a very fragmented institution because you have a lot of political parties, a lot of countries, and so on. But it seems that a fragmented institution works better in a polarized environment, like we are living now here and also in Europe, than an institution like the US Congress. So, it's not just that because we like regulation that we do more regulation, it's just because also we are able to pass them.
Okay, Dina, I'd like to ask you about the consumer welfare standard. You said that, it doesn't need to change much to deal with the problems that you've identified with big tech, but do you think it would nonetheless be a good thing if that was significantly revisited? I mean, what's the best framing of the consumer welfare standard in your mind?
Well, I'll give you a short answer. I think it's a very effective equation to sort of constrain antitrust analysis. One side of the coin is price, and the other side of the coin holds quality constant, so you can hold price constant and look at all the variables of quality. And I guess I haven't seen any alternative that doesn't make me nervous.
Yeah.
I think it is such a straw argument to focus on the consumer welfare standard constraints as to look at price or positive price or only downstream consumers. I mean, I can just tell you that in the investigations that I was involved in at DOJ, if we thought that the locus of competition was quality, that's what we focused on. Could we find adverse effects, say, of a merger on quality competition or innovation? If the harm was upstream to farmers who were selling their cattle to beef processors, then that's where the investigation went. I think the consumer welfare standard is a way of saying, we want to find harm to the competitive process, not to necessarily rivals of the firms that are involved. If it's just somebody's doing something more efficiently or has a better product and their rivals are losing market share, that's not an antitrust harm per se, unless there's some anti-competitive action associated with that. So like Dina said, I think it constrains our thinking. We're not looking at, say, the public interest the way the Federal Communications Commission investigates telecom mergers. But I don't think it stops the agencies from being concerned with a broad range of harms. I think the challenge is that courts expect quantification of economic effects to the fourth decimal place. And that's really the problem, is that we should be able to articulate the harm, to use business documents to articulate the harm, to explain how a merger or the action changes the incentive and ability of a firm to extract rents in an anti-competitive way. And if we've got empirical quantitative data, great, but if we can't provide that, quantification to the fourth decimal place, it doesn't mean that the plaintiff should go down. And I really see that as the problem with our enforcement system, not that we're constrained to only look at price, but that courts are reluctant to take kind of non-quantitative evidence, particularly if a CEO says, oh, but we would never maximize profits after the merger.
Henry, I think Nancy points to what I think would be a useful exercise to carry the debate forward. This is a broken vocabulary. You can start fistfights in bars now by just mentioning the phrase, unless you define carefully what you're talking about. But I think to appreciate how the consumer interest has been defined much more broadly, it's so informative to look at what agencies have done for a long period of time. And I think we could come up with a strikingly long list of matters in merger control, in non-merger cases, where innovation effects, for example, have predominated. Pharmaceutical cases, where it was the innovation pipeline that mattered. One after another, going back throughout this period, going back to the beginning, but going back through the period when the system was thought to become very cramped. Again and again, we see instances of cases where the innovation quality dimension of competition was the foremost basis, the foremost theory of competitive harm. And to the extent that an audience, a court, others, might think that departing from a single-minded focus on price in some sense is radical or unusual, I'd say I just want to remind you of how often that other analytical tool has been used. Indeed, you've used it in cases, in different instances. It doesn't have to scare you, that the notion of what is good for consumers is a good deal broader than the focus on price. I am astonished at how often commentators in the distilled, painful form of Twitter or of op-ed articles will say, for years antitrust has been obsessed only with price. Oh, come on, really? I have a filing cabinet with these cases, and when I read this, I think, my God, what have I forgotten? And I go back and look at them, and I pull out the complaints to talk about innovation, quality, and I say, yes, I have not forgotten completely. I think bringing that to the fore to say, this is a broadly accepted notion of what supports consumer interests might be informative.
But Bill, don't you think that getting those cases, if that's what they're based on, successfully through a court system, is challenging? I mean, I think many of them get settled because agencies are rightfully concerned that they won't be able to prevail.
You know, I'll go back to my RealComp case, and it is hard. But what's glorious about the Sixth Circuit's decision in RealComp is that the court modeled it the way that we pitched to the court, which is, this is disruptive innovation. The fee-for-service model, not 6%, where people now on the internet can do their own work and their own searching. This is a disruptive technology that has brought true innovation with price effects into the field. The court got that right away. They saw that. That's front and center and featured. I wonder if it's a matter of advocacy, of the skill of presentation, but I'd like to think that you can replicate that experience, but it can be daunting, and that's what I find really a concern in AT&T Time Warner, where because some of the high-tech analytical tools are available, the courts seem to be saying, as you mentioned, show me the dollar and cents. I want a bottom line effect. And of course, a good expert on the other side is going to pick the model apart or to raise questions about it. That's a real problem.
We're going to go to questions shortly, so please start thinking about what you'd like to ask the panel. But before we do, I just want to ask about one other aspect of the revolution that's taking place, which is a populist assault on the people involved in antitrust, saying that there's too much of a revolving door between the private sector and regulators, and that everyone's corrupted by taking money from big tech firms and being expert advisory witnesses in cases and so on. Dina, do you think that's right? Do you think that's a big part of what needs to change is sort of the ethical conduct of antitrust, I suppose?
Again, this is something that I've sort of, I tend to bury my head in the research and look at little else when I'm deep in the research. It's not something that I'm an expert on by any means. Yeah.
Do you think in principle there's a problem with regulators?
I've definitely seen examples where, yes, I think it's objectionable. I've seen a few examples actually in Europe where I was like, wow, really? That's fast. That's a fast flip. That looks objectionable. I think I'm more familiar with seeing those examples actually in Europe, but yeah, principally it's a huge issue.
Alex, do you have any thoughts on that?
Yeah, I mean, for me, I mean, of course, there are always some mercenary everywhere, so which are ready to defend everything for the highest price. But I think, you know, that's not, most of the people are not like that. And they are more influenced by their own prior, because I think we always have prior, and that is linked, I think, to our own past. I mean, I don't want to do psychoanalyst here, but I think I'm more interested, you know, by why do people are defending their idea independently of who is financing them. And I think we have our prior. We have to recognize that. And I think it will be much more interesting to discuss that, or to discuss also that, which is never discussed, than just who is financing you. I mean, I think it's a bit too much of a shortcut. But I mean, yes, it is an issue. There are some cases, of course, but I'm not very convinced that it is the main reason why, that is the reason why antitrust people are captured. I think it's more because they are in the same community, they speak with each other, and they are not enough open to the world. But it's not, I don't think it's mostly a financing problem.
All right, I'm going to open it up to questions now. So please, yes. Oh, there's a mic, I think, actually, yeah.
Thank you. I'm Cristina Cafara. I'm a consultant. I will describe my various conflicts at some point when I speak. I bring to this the experience and the background of an economic consultant, but I want to take issue with some of what Nancy said. I think what you said came across to me as something along the lines, oh, there's a lot of criticism around of economists, but in fact, there's a lot of people who do good work, especially the new generation, do really crucial work. It's exciting, it's great to see. I think that as economists, we need to be way more critical about the role we have played. And I'm saying this as a consultant first. Of course, there are some who can say, but you're consultants, who cares? You're just mercenaries. But I say this with cause, both about consultants and academics, because many academics consult and don't disclose. I think that the reality, as someone who's been at the coalface for 25 years doing cases, I've never been a regulator, but I've been at the coalface. The reality is that consultants have been fed snake oil stories, but by many economic key sort of papers. We know that stories around as efficient competitor test, we know the stories around vertical arithmetics are not very worthwhile, but they are used systematically in every case. And this is concerning because I do not see that there is a great deal of introspection on the part of the profession, saying what exactly are we feeding the lawyers in the way of snake oil that they can sell. Lawyers kind of like economists because they know we can give them these useful narratives, right? But I do not see that the profession has been particularly good. Generally, the consultants don't really have to because they sell it. But the academics have not been particularly good at saying, whoa, what are we really doing in a world in which we need to pursue enforcement? Briefly, you mentioned bargaining models. Yeah, you know, there's a few. They typically are used by defendants to say there's no problem. That's the reality of it. There are a few nice new articles by new economists, Florian Ederer, others, and the profession is critical of them generally. Oh, they're not quite dignified enough to be at the top journal level. So I think that as a profession, we have a collective responsibility, we as consultants for selling snake oil, but also the academics for not having pushed the boundaries at all. And the final point, there is a resistance to pushing these boundaries, because in a world in which we worry about privacy, data protection, I have to just convince people all the time that there is some interest there. People say, no, data protection is nothing to do with us. We are IO economists. We do market power here. We don't do privacy. It's like, hello, these things come together. How can we make progress along this together? No, but that's a fundamental right, so nothing to do with economics because there's no trade-off I can actually deal with. So, I mean, I intend to be provocative, but that's where I am.
Yeah, so I guess we just have extraordinarily different life experiences. You know, I've been spending my last 35 years teaching primarily antitrust and regulatory economics. And I know there are papers out there that you're describing. I will say they tend not to be the ones that are on my reading list, or if they are, they're contrasted with papers that show how dependent, if they're theoretical models, how dependent they are on the assumptions. I see, at least the way I've trained my students over the years and the way I was trained, to be fairly skeptical of one side or the other, but I think that the dominant theme that comes through at least the antitrust learning that I've done through the academic literature and what I convey to my students is that the narrow views of what I'll call the Chicago school, but this narrow view that markets are self-correcting and you know, everything tends to be efficient, and if it's not in the short run, it will get there very quickly, is not consistent with the learning. You know, if you're saying we have a disclosure problem in economics, I'm not going to argue there. I think we've made a little progress since the financial crisis, but we still are not where we should be. I didn't disclose anything because I have nothing to disclose. I don't work for private clients. I don't do expert work. But I don't think that is a consistent policy. I think we're getting better. And I think if there's an interesting fact to uncover or an interesting theory to put forward, there are strong incentives in academia to do that work and publish it. So, you know, if you're not getting traction with people working on privacy, maybe it's because people think they should be doing empirical work, and it's really hard to think about how you get the data to do empirical work on privacy. But you know, it's not to say anything you write is going to be accepted. There'll be a healthy debate, but you know, I think if something like Tom Woolman's short piece on stealth consolidation or Florian's piece on killer acquisitions has had huge effects on the academic debate. It's had huge effects in terms of catapulting them to the front of people who are recognized as exciting young scholars. And, I think those incentives are there.
All right, yes, I think there's one over here, yes. Oh, yeah, that's Mike.
Thank you, Alden Abbott. I like Bill Kovacic's comment about case law. I think look at the U.S. Microsoft case, for example. This was a case in which a D.C. Circuit, and Judge Doug Ginsburg had a lot to do in writing it, in effect was able to look at arguments, not about quantification of loss of surplus, but he says, look at these arguments defending the supposed deficiencies. There are a number of them. Some of them are potentially credible, others are not. And if we find some arguments that a non-exclusionary argument is pretextual or not very credible, we're not going to credit it. You lose. So I think that sophisticated courts, and again, advocacy is important, as has been pointed out, but I think a sophisticated U.S. courts will get that. And I think, as was mentioned, innovation has really shown up in court decisions, frankly. I think that's underestimated. Also, the concerns about the agency's problems. Look, recently a major vertical merger, NVIDIA ARM was dropped in the face of FTC opposition. Semiconductor, there were some complicated theories of potential anti-competitive information exchange, but it was dropped. Illumina Grail, which is an argument about future harm to competition in a market which hasn't really developed, is actively being litigated. So again, I say that yes, cases are hard to win, but as is pointed out, I think if you've got a good story, it's not an impossible task. So again, I think I would point that out. I think there are good judges out there who, if they're given a good story, will understand potential harms to innovation and quality. Thanks.
Would anyone like to respond to that, Bill?
I mean, this is an academic's bias, and it could be an unrepresentative view of the world and not necessarily reliable for policymaking, but I do find case studies to be informative. And I think detailed examinations of experiences where you won, where you succeeded, and to identify how that happened. What mix of skill, luck, and for sure there's luck involved, but what collective effort, what sort of portfolio do you have to build in order to put yourself in a position to have success? I think that's a very informative way to think about going ahead, and I'm afraid in many agencies, the imperative to do the next thing keeps you from taking an informative look at things that have worked before. If you're going to devote effort to this kind of retrospection, and Nancy referred before how it can be very informative. The sense is, I can't afford, I don't have time to do that because I've got to bring the next one. And you say, well, but you'll bring the next one better if you can take this into account. And maybe this is futile. I mean, that's the active faith in it. It could be futile. But I'd like to think that if you do, especially to courts that are intervention skeptics, say, this is what other intervention skeptics have done and embraced arguments. In Microsoft, famously, the DC Circuit said, well, Microsoft says there's been no actual proof of harm. And the court said, you don't need actual proof of harm. Likely harm will do the trick where the behavior is especially threatening and dangerous. That's a nice principle to be able to carry forward. So I'd like to think that, assume that Congress will not come to the rescue with basic changes. You're going to have to work through the courts, and instead of surrendering, and it can be despondent at times to think about what you face, I think there are footholds in some of this earlier experience, but you have to spend some time looking at them.
Could I just say, I think sometimes the agencies have learned even more from their failures. So the FTC Hospital Initiative is the classic example of that, where after going down in flames on a number of hospital challenges, they went back to the drawing board, figured out how to win. Now, what's appalling to me is They do tend to win, but often they're still losing at the district court level. So it's like hand-to-hand combat, and that's what I mean by the challenge posed by the judiciary. In the DOJ case, I think it was the Oracle PeopleSoft case. They went back, oh my God, why did we lose this?
And I think, Nancy, it's an indication of how you have to be in for the long run, the persistence. Coming to the FTC in 2001, Bob Potofsky very clearly said, I give up. That is, this is the Bermuda Triangle into which cases go to die, and I quit. You have new leadership that says, maybe not yet, and says, let's do the studies, let's go to HHS and collect data that shows the adverse effects of past deals. We'll do the studies, and 2 or 3 years from now, we'll start the cases. By the end of the decade, we'll be winning these cases, albeit sometimes through the appellate process. But that was a commitment that said, even if it doesn't pay off right now, if we do this right over a period of time, we will change the framework. And I'd like to think that you can do that again.
With resources.
Yeah.
I will say, I just think anybody who cares about antitrust policy in the US, the first, second, and third thing they say as priorities should be, we need to double the agency's budget and we need to increase the comp scales.
Allison Jones and I said, give the FTC $1 billion a year and see how it goes. I haven't heard the resounding approval for that in the Congress.
We won't hold our breath. Question at the front.
Hi, I'm Adam Lashinsky. I'm a journalist. I've covered Silicon Valley for a very long time. Nancy, you elaborated a tiny bit on your comment about how you don't think the big tech is the only or the most important consideration for antitrust. I wondered if you had more to say beyond the comment you made that there's more to it than 5 companies. And I also wonder if you could comment on the sort of flip side of that, which is if you can generalize, would you generalize that regulation may be more appropriate than antitrust enforcement anyway?
All right, so let me start with the last. So I mentioned I teach the second semester of our graduate I/O sequence. It's antitrust and regulation. I describe antitrust as what you do ex ante to prevent the accumulation of market power through anti-competitive means, be they mergers or conduct. And I describe regulation as what you do when you didn't manage to succeed with that, when you have persistent market power that creates a problem and you need to do something about it. And in between, we may have market power, industries with market power, sectors with market power that we don't regulate because the costs of regulation are high and regulation is not perfect, just as markets are not perfect. So we may in tech, in some of the areas of tech, be in a situation where the immediate solution to the existence of market power is a more regulatory solution. I echo what Bill said. I think what the CMA is doing is extraordinarily exciting and compelling and should be a model. I fear it's not a model for the US because the UK has historically had a very expertise-based regulatory system across all areas. The US tends to, no knock on people, but tends to appoint kind of people with political power or political connections to regulatory agencies, and I think often that doesn't provide the same type of initiative and expertise needed. But to go to your first question, why did I say I don't think tech, particularly 5 tech companies, is the biggest problem we have? Because those companies, we're increasingly we're challenging them, right? But I think part of what the great dialogue over the last several years has been is to show us that it wasn't, as Dina explained, it wasn't that they just got to be big and dominant because they were so great at doing what they did while being, just great competitors. But we have things like exclusionary behavior or acquisitions to take out potential competitors or acquisitions to increase their power in the ad tech space. I think that kind of example tells us that if all we focus on are the current market power problems with tech, and especially with these 5 companies, we're allowing others to exercise anti-competitive market power or to acquire their competitors or potential competitors or to preclude others from rising up to become rivals to them. And the 5 companies that are our problem today may still be our problem in 10 years, but we may find we've got a lot of others as well. And I just think if you look at the scope of merger activity, having more effective merger policy that really deters anti-competitive mergers would go a long way toward preventing consolidation in some sectors. So that's what I mean when I say I don't think it's our biggest problem is we've got all the other sectors of the economy that are still being subject to what I see as relatively lax or too lax antitrust enforcement.
We had one at the front here.
Thank you. I have a question for everyone from a bit of a different perspective. So it seems to me that until when antitrust was stable, let's put it like this, 2015, was also a world of convergence. No? Like antitrust policies had a goal. We were discussing the more economic approach in Europe, etc. There was not full convergence, but there was a direction. And we built a gigantic infrastructure to ensure this. No, we have the ICN, we have the OECD, the UNCTAD, and these places where you would discuss policy and try to reach a common world. And it seems to be that now we are diverging. We are talking about experimentation, different countries passing different laws. There are so many goals that people are interacting. So what does it mean to this world? Is there any hope for convergence anymore? Are we in a world of total divergence? And what does it mean when you have more and more different jurisdictions starting to enforce antitrust in Africa, Asia, South America, anywhere? So I wonder what your thoughts are on this topic. And what's going to be the future of the OECD, ICN? Is there a future for them, or is it just like, oh, maybe it's no longer there?
Alex, do you want to?
Maybe.
I'll mention one. If you're going to, there's a model of policy development and norms development that has 3 stages. One is experimentation that's decentralized, then a process of identifying what seems to work best, and then opting in voluntarily. And sometimes the opting in voluntarily becomes the basis for more binding commitments over time. So you tolerate the experimentation, maybe you welcome it. Because in tech, for example, might it be a good idea that you have the DMA running, the DMU cases, so you figure out what's working, what has the greatest promise, because in a sense you don't know. You don't have a completely confident view of what the right solution is, so you welcome the experimentation. But then second, you want a mechanism for taking stock of what's going on, so that people understand good things, bad things about what's happening as a way of singling out what seems to be more promising. And then last, if people see that there's something that works, like leniency, like pre-merger notification, they say, I'll have one of those too. And they'll embrace them. So how do you get it seems to me that a lot of attention has to be focused on those second and third stages, especially the second. And I think there's a broader debate inspired here in this room in part over the years is which organizations are legitimate to provide the consensus building about what seems to be working. Who should be in the room? How diverse are those interests? And the concern with the traditional organizations is that that's been too insular. Are academic hubs, again, a place where you want to begin that, where you can have more people in the room, you have forums such as Booth, you have EUI in Florence, you have a variety of different forums. Is that the place where you want to focus the consensus building, where you bring the right people in the room to have the right conversation to do that? And then to have perhaps them work in collaboration with some of these other organizations. I mean, you're familiar, Filippo, as I am, that the critique of the other organizations is that they are not representative. And that those organizations did not inspire this debate. It didn't happen there. It happened on the outside. The traditional organizations were bypassed and are now sort of running to catch up and get on the train. So how do you ensure that the consensus building process is representative and picks things up as they're coming over the horizon instead of trying to catch up later on? But I think academic organizations have a lot to add to that process.
I'll add one thing.
Yeah, please.
Just to echo that, I see these things as happening in a state of chaos initially, but we do see a lot of convergence right now. I'll give a couple of examples. We see convergence between, for example, the bill that the Senate is working on for advertising exchange markets in the US and the principles and rules one would apply to those exchange markets, and all of the enumerated rules that the CMA recommended for the same markets. And equally, we have the Competition Authority in Australia looking at these markets from the same lens. So that is a lot of convergence across the world. We also have convergence, in how we think about data and competition and Facebook and social network markets between Germany, litigation happening in Germany and litigation in the US. So just wanted to put those 2 examples out there.
Yeah, I just
Briefly,
also
please.
want to say, I mean, I think there are, in tech, for instance, there is a kind of a convergence. I would not say that there is a kind of divergence, but for the identification of the problem, now I think the next phase is implementation of those new law which are adopted or are about to be adopted. And there maybe we would need a new forum, you know. And I think like we have the Basel Forum for the banking regulation, I think we probably need to have a kind of a new forum for the big tech regulation, which I think should not be in antitrust, because I think it's a regulatory problem. So we need another forum, which is a regulatory forum and not an antitrust one.
I'm afraid we've run out of time. Sorry about that. I'm going to have to leave it there. I don't want to kick off the day running behind schedule. Thank you very much to our panelists for a wonderful discussion there. Can you join me in thanking them? I think we're going to go to a 15-minute break now. I look forward to seeing you in...